Okay, hi everyone. It's 4+5, so perhaps we can make a start. Good afternoon, everyone. Thank you so much for joining us on a Friday afternoon. Today's webinar marks our firm's first collaboration with VILAF, which is a preeminent Vietnamese law firm boasting one of the largest teams of English-speaking business lawyers in Vietnam today. VILAF regularly handles maritime, finance, investment, and construction disputes, and has in recent years become increasingly involved in resolving disputes by way of arbitration. We're very honored to have Linh and Thuong joining us today from the Hanoi office, as well as our own Linh from STSP. They'll be sharing their views on evidence in arbitration from their own respective local perspectives. Allow me to briefly introduce each of our speakers. We'll go in order of seniority, so we'll start with Linh. Linh has been a partner at VILAF since 2000 and has extensive experience in corporate, commercial, and dispute resolution work. He has won numerous accolades and has recently been ranked by the Asia Business Law Journal as one of Vietnam's top 100 lawyers. Outside of his counsel work, Linh sits as arbitrator of the Vietnam International Arbitration Center and as a mediator of the Vietnam Mediation Center. Thuong, sitting beside him, has been a senior associate at VILAF since 2019, and she writes prolifically. She has recently published a guide entitled International Arbitration 2023 for Chambers and Partners, and in 2018, Thuong conducted her traineeship at the AIAC, where she was involved in revising the AIAC rules, amending the AIAC standard form of building contracts, and drafting the Asian Institute of International Dispute Resolution Charter. Linh will provide the Malaysian perspective to the discussion today. She is an associate at STSP, having joined the firm in 2019 as a pupil. Linh has an active construction practice and recently acted as co-counsel in a construction arbitration where the amounts in dispute were in excess of 800 million ringgit. And there she was instrumental in handling the expert evidence in relation to construction delay and quantum. Now moving on to the topic of the day. Vietnam adopts an adversarial system, as does Malaysia, and the way in which evidence is prepared, presented, and treated in an arbitration may be governed by a variety of rules and common practice. So of relevance may be any agreements between the parties, any applicable institutional rules, the IBA rules, and any applicable national laws, for example, the law of the seat of the arbitration. So hailing from a different legal tradition, Linh and Thuong will be sharing their views on the rules and procedures governing the taking of evidence in arbitration in Vietnam, with specific reference to the VIAC rules of evidence and the IBA rules on the taking of evidence in international arbitration. They will canvass the presentation of documents, the handling of witnesses of fact and expert witnesses, and the conduct of evidentiary hearings in Vietnam. Now, from the Malaysian perspective, Lin's presentation will make reference to Section 21 of the Malaysian Arbitration Act 2005, Article 27 of the UNCITRAL Arbitration Rules, and recent Malaysian case law. She will also touch upon the ability of the tribunal to draw upon its own personal expertise, experience, and knowledge, and the taking of expert evidence by way of the hot tubbing procedure in complex construction disputes. So I'd now like to hand the floor over to Linh and Thuong for their presentations. Linh and Thuong, over to you.
Thank you, Don, for your kind introduction. Before we start our topic today, I just want to take a few minutes to introduce a bit about VILAF, although you already said a very good thing about VILAF. But VILAF, we got 15 partners, and we are one of the largest law firm in Vietnam. We got more than 100 staff members in both Hanoi and Ho Chi Minh City. We practice all business law, not only the dispute resolution. So that's very quickly, we are one stop shop for Vietnam. And I also, because I also an arbitrator of Vietnam International Arbitration, VIAC, so I just would like to briefly introduce you about VIAC. I would say VIAC is the largest largest arbitration center in Vietnam, although Vietnam have about more than 20 arbitration centers, but VIAC is the largest one. I just want to show you some statistics in 2022. VIAC have received 292 cases, new cases, and handled by VIAC. This figure is about more than 8% increase in comparison with that of 2021. So according to VIAC statistic, the total number of cases that VIAC handled from 1993 to 2022 is about 2,530 cases, of which about 40% domestic dispute and about 60% is foreign element dispute. In 2022, VIAC also have been handling a wide range of dispute, not only sale of goods, representing about 37.5%, is remain the predominant type of dispute, accounting for the highest proportion of cases handled by at VIAC. And you can see in the on the screen that the next one is the construction, and then finance and banking and real estate. And about the geographical origin as part of the parties, there are about 60 nations and territory around the world is a VIAC user. And you can see here that the top 5 foreign users is China, Singapore, Japan, South Korea, and the US. And I think that we come back to our today main agenda is about the evidence formality and taking evidence in arbitration in Vietnam. In this session, Ms. Lê will present you about those issues, and she will run through some Vietnamese court decision that she will also highlight some kind of, the hot issue that you may face in the arbitration. So I pass the floor to Thi Thuong. Yeah.
Yes, hello everyone. I'm Thi Thuong from VILAF, and today I would like to discuss with you some aspects of the evidence in arbitration from Vietnamese perspective. So in this discussion, we're going to first go through the rules and practice of evidence formalities and the the laws of Vietnam and the rules of arbitration center in Vietnam. And in the second part, we share some parties of the applications of IBA rules on the taking of evidence. And in the last part of this discussion, then we will discuss about the collection of evidence by the Arbitral Tribunal, like is the obligation or is the right and power that they could order the party to produce. So now moving on to the first part on the rules and parties of taking evidence in Vietnam. So before we go into discuss in detail about the rules of the formalities of evidence in arbitration applied in Vietnam. So we first talk about the rules, the laws that govern this aspect of arbitration. So indeed, there is no specific set of rules of evidence formalities and taking of evidence in arbitration in Vietnam. So if you look at the IBA rules on taking of evidence, so hereafter I just refer to as the IBA rules. So if you look at the IBA rules, it walk the reader through like the documents to be provided, the witness of the statement of witness or is supported by the party, and how the tribunal would determine the materiality, the relevance, and omissions of the evidence in arbitration and etc. or evidence-free hearing. So in Vietnam, we don't have that kind of set of rule apply on evidence in arbitration in Vietnam. However, in the rules of arbitration center, they have some kind of umbrella clauses of provision that may allow the arbitrators a broad power to decide on the matter that's not expressly provided under the rules or under the law. So now let's look at some of them. See, like in this one, like as you can see in the screen. So here is the rule 38 part 5 of VIAC rules of arbitration. So in this provision, this umbrella provision saying that in all matters not expressly provided for in these rules, the centers and the arbitral tribunal shall act in the spirit of these rules and make all efforts for the dispute to be resolved in a fair and efficient manner. So why is it not very clear, like how to understand in the spirit of these rules? But what we can see in this provision is that it allows the tribunal the power to resolve all the matters before them in a fair and efficient manner, how to resolve the dispute in a fair and efficient manner. And with these provisions, it could be understood that the tribunal have the power and the authority to decide all matters laid before them in a way that they consider is to be efficient and the fair treatment to the party. So now look at the parties. So how the tribunal would handle, like how the tribunal, the arbitration centers and the court view or take the views of these matters in the parties. So now we move to the parties of evidence formalities in Vietnam. So what interesting about arbitration in Vietnam is that, like in my point of view, it's very unpredictable. Why? It's because the court, they share the different views and they share inconsistent patterns of how they consider the matter submitted to them in relation to arbitration. For example, so in the matter of the formalities of evidence in arbitration, so there's a lot of cases where the courts decide the matter of evidence. The matter of evidence is a substantive issue. For example, in decision 1358, dated September 28, 2017. So in this decision, as you review the decision, it appears that the applicant, the award debtor, challenged the award on the ground that they challenged the authenticities of the qualities analysis report, which were not stamped and sealed, and it is difficult to identify who was the one who conducted the analysis of the product, and the contents of the report show that it was erased and modified. So the applicant challenged the awards based on the ground that the tribunal may rely on a forged evidence to decide the case. So that's one of the ground to set aside to annul an arbitral award under the law on commercial arbitration of Vietnam. So in deciding the challenge by the applicant, so the tribunal, the court ruled that the applicant, the award debtor, could not produce the evidence showing that the reports were forged. And in any event, assessing evidence is a substantive issue that the court would not release. So, but this decision is not a single one in of its type. For example, another example for this view is the decision 1368, dated October 14, 2019. In this case, the award debtor challenged the copies of emails submitted during the arbitration proceeding on the ground that the emails may be forged. Like in the decision, it didn't discuss like on what ground or on what basis the applicant doubt the authenticities of the emails. However, they submit the matter to the court, and the court took the view that as long as the issuer of the sender of the emails, which was the award creditor, omit such emails, and the copies of such email cannot be forged. So as long as the one who sent the email omit the email, then there's no way that the emails could be forged. So that's the view of the court. And also the court reiterated the view that in any event, assessing evidence is a substantive issue which the court did not revisit. So in these two decisions, the court doesn't mention at all like what kind of rule would be applied to determine or to assess the evidence submitted in the arbitration proceeding. However, there's also other decision in which the court take a totally different view. For example, in decision 1208 dated August 3, 2022. So in this case, the award debtor challenged the tribunal dismissal of the copy of electronic invoice, which were the key evidence to determine the claim made by the claimant in the arbitration proceeding. So in this case, the court referred to Article 95 and Article 96 of the. Excuse me. Do you see the? Do you see the slide that I am showing?
Actually, Thuong, it's still on the first slide.
Okay. Let me check with our technical team how to move the slide. I just want to be sure that you follow with our presentation's first part and how it's running. Did you follow our presentation?
Yes, Thuong, we did. Okay. It's just that I think the slide is stuck on slide 1.
Okay. So you see our slide now?
Yes.
Okay. Okay, so now we move to the different view. Like now we discuss about the different view of the court with respect to the formalities of the evidence in arbitration. So a while ago, I tried to discuss with you that in a lot of cases, the court takes the view that it is the substantive matter which the court did not revisit, including the challenge against the authenticities of evidence, even though there is one ground under the law on commercial arbitration of Vietnam that where the court rely on a false evidence to decide the case, the arbitral award would be cancelled, would be annulled. But yet, in many cases, the court take the view that it is a substantive issue and the court would not revisit. But there's a lot of cases where the court take a totally different view. So, for example, in decision 1208, dated August 3, 2022. So in this case, the arbitral debtor, the award debtor challenged the tribunal dismissals of the copy of electronic invoice, which were key evidence to determine the claim. So in this case, the court otherwise referred to Article 95 and Article 96 of the Civil Procedure Code, which require the copy of document to be notarized, and conclude that the copy of electronic invoice which were not notarized cannot be admitted. So the tribunal did the right thing that they dismissed the copy of the electronic invoice. Nevertheless, when we refer to Article 95, paragraph 3 of the Civil Procedure Code, it's provided that the electronic evidence, the electronic document, is acknowledged as an evidence in the court proceeding, so it requires no notarization. Nevertheless, in this case, the court agreed with the tribunal that the dismissal of the electronic evidence is the right thing to do, and then they upheld the arbitral award. Then in another case, in decision 1079 dated July 2023, dated July 23rd, 2022. So in this case, the award debtor, they challenged the tribunal omissions of a false evidence, which was the copies of letters of consignment, for the reason that the award creditor did not produce the original copy of flow letter of consignment. So in this case, the court also referred to Article 95 and 96 of the Civil Procedure Code, which required the copies of document to be notarized, to be admitted as evidence in civil proceeding, and conclude that for the reason that the award creditor did not produce the original copies of those letters, then those letters must be dismissed. But in that case, the tribunal omit those letters, the copy of those letters of consignment. So the tribunal breached the law on commercial arbitration that they rely on false evidence to decide the case. So now we look at the two decisions. Decision 1079 and decision 1358. So in decision 135,
perhaps just stop you there. The slide isn't moving again. Perhaps you want to move to
yeah,
slide.
sorry, we didn't because the number of the decision is the last, so we didn't put it in here. So yeah.
Okay. Thank you.
Yeah.
Sure.
So now we let's compare the court view in decision 1078 and the court view in decision 1358. So in decision 1358, the court took the view that the burden of proof of authenticities lie with the award debtor who challenged the award. So if they find that, if they consider or they believe that the evidence was false, then it is their burden of proof that they have to show evidence to prove that the evidence was false. But in decision 1079, the court takes the view, opposite view, saying that it is the burden of proof of the award creditor who was challenged, that they have to produce the original version of the evidence to show that they didn't forge the evidence. So just in this regard, we see like how inconsistency the court take the view. And in another scenario, now we want to compare the decision 1208 and decision 1389. So in these two cases, they both challenge the electronic documents produced as evidence. But in one case, the court took the view that as long as the issuer of the email acknowledge and omit the email, then there's no way the email could be considered as forged and it should be omitted. But in case 1208, the court took the view that the electronic invoice could not be omitted as the evidence, even though under Article 95 of the CPC of the Civil Procedure Code, it considers as an evidence. So yes, so see, like in this regard, we see like not only that they take a different view about the matter of evidence, whether it's either procedures or it's a substantive issue, but they also take very different view towards how to assess the evidence themselves. So now we move to the very controversial case that arising recently. That's the decision 12, 2023. So in this decision, like as brief in this summarized in this decision, so the award debtor, they challenge the awards on following grounds. So they rely on the fact that the POA, the power of attorney, was not legalized, and their views were that it must have been legalized. And they also reason that they invoke that it's impossible for 5 members of the board locating in different places to sign on a single board resolution to appoint the representative of the company in the arbitration proceeding, which lead to the BOA. So, and the signatures of one member in the non-legalized BOA and the legalized POA. So after they challenging the POA, they're saying that the BOA was not legalized and it was wrong. So the award creditors in the arbitration proceeding, they produced another POA which was legalized. And when they compare the two versions of the POA, one with legalized and one not legalized, and they say that the signatures of one member of the court in the POA, these two POAs were not identical. So on these 3 grounds, they conclude that the non-legalized POA that submitted from beginning of the arbitration proceeding was likely forged, and they challenged the tribunal. They request the arbitration centers, in this case the VIAC, to stay the proceeding and to return the request for arbitration to the award creditor for the award creditor to resubmit the request for arbitration. And they also challenged the tribunal tradition because there was no arbitration agreement between the respondents and the authorized representative. So
I just want to add one fact. That's when Thuong mentioned that it's impossible for 5 members of the board locating at different places to sign the single board resolution. The reason they make that argument is because it happened during the COVID time. So they believe that one board member cannot travel from Thailand to Singapore to sign the board resolution and back to Thailand in a very short period of time. So that's the reason why they mentioned here about the 5 board member could not sign the board resolution at different places.
Yes, and when they make this kind of argument, I believe that they totally forgot how advanced the courier service in this age is. Like, you know, like we can courier everything worldwide in 2 or 3 days, but it seems that they totally forget that fact. And indeed, the member it's necessary for the old member to sit in one place to sign on a single board resolution, right? But anyway, they make those kind of arguments and they challenge the tribunal tradition on the ground that because the authorized representative was not properly authorized. and there is no arbitration agreement between the authorized representative and the respondent. So it means that the tribunal didn't have the jurisdiction over the dispute arising between the claimants and the respondent. So because of this challenge, the tribunal decided to bifurcate the proceeding. So they held a preliminary hearing to decide the matters of jurisdiction. So in this, as summarized in the decision 12, the tribunal indicate the view that because the respondent, they refer to Decree 111, which required the documents of foreign entity to be legalized, to be admitted in Vietnam. So the tribunal referred to Article 9, Paragraph 4 of Decree 111, which allowed documents of foreign entity to not legalize if the receiving agency in Vietnam do not require the legalization. And VILAF and tribunal did not require the POA to be legalized. Indeed, in the practice of VILAF, as well as we may know, like they don't require the document to be legalized or to notarize. It's all up to the tribunal and the party to the proceeding. So in this case, the tribunal reiterates the view saying that VILAF and the tribunal did not require the POA to be legalized. So is it properly done in accordance with Article 9.4 of Decree 111? And in the decision 12, because they don't summarize everything, so we do not have the information available to see how the tribunal decided the relevance between the legalization of the POA with the jurisdictions of the tribunal over the dispute. And then let's see how the court consider this matter. So the court disagreed with the tribunal, saying like the tribunal saying that relying on Article 9.4 of Decree 111, which allowed the document to be not legalized if the receiving agency do not require, and the court disagreed. So in disagreeing with the tribunal, the court referred to Article 4.1 of the Civil Code, which provided that the Civil Code is the general law to govern the civil relations. And they also referred to Article 1 of the Civil Proceeding Code, which provide that the Civil Proceeding Code take part in protection of justice, human rights, and citizen rights, the socialist regime, the interests of the state, and the lawful right and interests of agency, organization, and individuals, and educate people on strict observation of law. So on these two grounds, they conclude that the Civil Proceeding Code is the general law, and the law on commercial arbitrations is a specialized law. So the provisions of the Civil Proceeding Code should be applied on the matter which the law on commercial arbitration is silent about, including the matters of evidence formality. So when they refer to, we find that when they refer to Article 1 of the Civil Procedure Code, it seems that they totally ignore the very first part of this Article 1, which saying that the Civil Procedure Code would apply exclusively in civil proceedings, but never that. So they take that view and to see that the law on commercial arbitration is a specialized law and the Civil Procedure Code is a general law, and the Civil Procedure Code would be applied in whatsoever area that the law on commercial arbitration is silent about. So this, and beyond this one, the court further take the view that in accordance with Article 9, 1395 of the Civil Procedure Code, the POA must be legalized. So the tribunal viewed that Article 9, Paragraph 4 of Decree 111 of Light is wrong, and the POA must be legalized. And the court further relied on the fact that on the schedule of one board member, which is on the 9th of July 2021, she attended an event in Thailand. And then in July 19, 2021, she attended another event in Thailand. Then the court took the view that it's impossible for her to travel to Singapore on July 12, 2021 to sign the board resolution given the COVID lockdown in Singapore. And luckily, the POA was forged. And by relying on the non-legalized POA to proceed with the proceeding, the tribunal breached its impartiality obligation. So now, let's compare decision 12 and the decision 1369 that we discussed before. So as you may recall, in decision 1369, the court took the view that as long as the issuer of the email acknowledge and omit the email, then there's no way the email was forged, right? But in this case, the POA was issued by the claimant, and the claimant acknowledged the POA. It's just a matter of formality that whether it's legalized or not legalized. But the court took the view that by relying on, first, they dismissed the non-legalized POA, and second, they find that by relying on the non-legalized POAs, the tribunal breached its impartiality obligation. So the decision 12 is not the very first kind of it, the very first one of its kind in which the court referred to the civil procedure court to annul an arbitral award. But in this case, it's the very first kind of it, the very first one of its kind that in which the tribunal and the court explicitly discuss about whether or not the legalization and notarization should be required, and the tribunal power in deciding this matter. So, and the court totally dismissed the right of the tribunal. So saying that, no, you cannot do that. If the law and commercial arbitration doesn't provide such a thing, then you rely on the civil procedure court. So that's how the court took the view in this case. Yes. So now we move to the applications of the IBA rules in Vietnam, whether it is allowed or not. So for the practice of application of IBA rules in Vietnam, it's not really common to do so. Notwithstanding, there's some case in which the tribunal still refer to arbitration as the guideline and reference to decide the matter of evidence in arbitration. So here we would like to refer you to two cases in which it indicates how the court take the view like consider this matter. So the first one in decision 11 in 2019. This is one of the very controversial decision of Vietnamese court, and indeed, as well as we may know, this is the subject of an investor-state dispute to which Vietnam is a respondent at the time being. So in this decision, even though the party did not raise the issue of applying the IBA rules by the tribunal, yet the court referred to this fact and saying that because the IBA rules do not bind even the tribunal and the parties. So as I said, because in this case, the challenging party, they did not refer to the fact that the tribunal applied the IBA rules. So we don't have information to see like if the party agreed for the tribunal to apply the IBA rules in advance or not. So the court took the view that the IBA rules is not compulsory and it does not bind even the tribunal and the party. So by relying on the IBA rules to decide the matter of evidence, the tribunal failed to observe Article 56, Paragraph 2 of the Law on Commercial Arbitration and Rule 25, Paragraph 1 of the VILAF Rules, which require that the tribunal rely on the available evidence in the case documentation to decide the case. Why the court referred to this provision? Because in this case, the respondent, they was very recalcitrant. So they didn't participate in the hearing. They challenged everything that the tribunal did. So they did not attend the hearing. And according to Article 56, Paragraph 2 of the Law on Commercial Arbitration and the Rule 25, one of the VILAF rules, it required that where the respondent absent from the hearing, the tribunal would rely on the available evidence in the case documentation to decide the case. So the court took the view that the tribunal did not rely on comply with Article 56, Paragraph 2 of the Law on Commercial Arbitration and rely on the IBA rules to dismiss the evidence submitted by the respondent. Then they breached the procedure's obligation. So with this ruling, it seems that everything that the parties submit in an arbitration proceeding seem to be evidence. So with that regard to whether it's relevant or not, whether it's material or not, or whether it's admissible or not. So as long as the parties submit anything in the arbitration proceeding, then it should be considered as evidence. And then in another case, in decision 1420 in 2019, so in this case, the party agreed that the tribunal may apply the IBA rules in deciding the matter of evidence with alteration where the tribunal find necessary. But it ended up that the tribunal did not apply the IBA rules in deciding the matter of evidence. Then the award that they challenged the award on the ground that the tribunal breached the party agreement. They didn't follow the procedure rules that the party already agreed. But then in this case, the court took the view that it's not a procedure breach, because even though the party agreed for the tribunal to apply the IBA rules, but the IBA rules is not compulsory, then it's up to the tribunal to apply the IBA rules or not, and not consider it a breach, a procedure breach. And the tribunal and the court upheld the award. So when we discuss these two cases, so it indicates what we can conclude. The first thing is that IBA rule is not compulsory, and because it's not compulsory, then it's be very risky to apply the IBA rules in deciding the evidence, because it may expose the arbitral award to the risk of being annulled, being satisfied. And on the other hand, now let's compare the things that we discussed in the very first session of this discussion and this part. So if the provision under the civil procedure code is compulsory and should be applied where the law on commercial arbitration is silent about, then there's no room for the party to agree on apply for the party and the tribunal to apply the IBA rules, whether the party agree for the tribunal to do this or not. Okay, so now we move to the next part, the next section. This is about the obligation of the tribunal, like the collection of evidence by the arbitration, by the arbitrator, whether it's the burden of proof, like whether it's the burden of proof of the tribunal of the claim or not. So in that, before we go into discuss whether it's the obligation of the tribunal or not, now we discuss about the legal system in Vietnam first, to see how, like what is its nature and characteristic. So Vietnam received the legal system development support from the US. And they reached the enactment of the Civil Procedure Code in 2004. So as one of the conditions of the US support, it required the transition of Vietnam's civil procedure system from inquisitorial system to adversarial system. And among the others, the Civil Procedure Code adopt the advocacy principle, under which the party have the authorities and the responsibility to produce relevant facts and evidence that become the foundation of the judgment. And the role of the church in this system is very limited and restrained, whereby they are compelled to a great extent to decide the case based on the evidence and fact resolved by the parties. So even though like the Civil Procedure Code 2004 was replaced several times, and the current prevailing ones is the Civil Procedure Code 2015. But this system still like get along with the replacement. And for the law on commercial arbitration, we adopt the same system. That is the adversarial system. So let's look at how the law on commercial arbitration provide this thing. So we observe here some relevant, several relevant provisions. So, for example, under Article 30, Paragraph 2, Lit D of the Law on Commercial Arbitration, so it requires that the request for arbitration must have ground and evidence in support of the claim. Article 35, Paragraph 1, Lit C of the Law on Commercial Arbitration require that the statement of defense must have ground and evidence in supporting of the defense. And likewise, and then at Article 46, Paragraph 1 of the Law on Commercial Arbitration, it requires that the parties shall have the right and obligation to provide evidence to arbitral tribunal to prove the facts relevant to the issue in the dispute. The Law on Commercial Arbitration also provides for the tribunal right to request for information or to material from the witness and from the expert, but it's provided as the right and the power to do so at its own initiative or at the request of one party, but it's not the obligation. The obligation still rests with the party who have the rights obligation to prove the claim that they make before the tribunal. So now let's look how the court take the views of these matters in practice to see whether the tribunal have the obligation to collect the evidence, to investigate the fact, or to investigate the evaluations of the value of the properties in dispute or not. So now we come back to decision 11 in 2019. So another ground for the court to annul the arbitration underlying this decision 11 is that. So in that case, the party did not agree on the damage. And because the respondent did not appear in the proceeding, they just submit some kind of evidence and they challenge most of the things that the tribunal do, and they didn't attend the hearing. So the tribunal relied on the expert report produced by the claimant to decide the case. So at this part of time, I think that the tribunal did the right thing, because under Clause 21, Paragraph 1, 25, Paragraph 1 of the Law on Commercial Arbitration, it required that the tribunal rely on the case documentation available to decide the case. So I think this should be the right thing for the tribunal to rely on the expert report provided by the claimant to decide the claim. Nevertheless, the tribunal take a very opposite view, saying that because the party did not agree on the damage, then the tribunal should have sought the expert advice of damage. Nevertheless, the tribunal did not seek the advice from an independent expert, but rely on the expert report provided by the claimant. Then it's a procedure breach of Article 46, Paragraph 3 of Law on Commercial Arbitration. So now let's look back at the Article 46, Paragraph 3 of the Law on Commercial Arbitration. What it say? So I say that the tribunal shall have the right on its own initiative or at the request of one or both parties to seek the expert's advice. So what is the right now become the obligation, right? But I mean, these decisions is not alone. Like there's not, like they are not isolated. The courts also take the same view in decision 04 in 2020. So in this case, the award was annulled because the tribunal did not collect the evidence at the request of the award debtor for reason that the request was unclear and unspecific. So as you may recall, under the IBA rules, it's required that the request for document version must be very clear and specific. Even though, I mean, it is not preferable for the requesting party to just say something in general, like something in the possession of the opposing party, which relevant to the matter that they request. Even such a thing is not preferable under IBA rules. But in this case, the tribunal did not collect evidence at the request of the award debtor for the reason that the request was unclear and unspecific, and the court found that it is something like a procedure breach. And also the court also referred to another conduct of the tribunal in which the tribunal did not request the productions of the audit reports of the award creditor to consider the material aspect of the claim. So basically, the tribunal have the right to decide on the evidence supported to them, produced to them, and to say like if it is enough for them to decide the case, then it should be filed. But in this case, the court took the view that the evidence available before the tribunals was not enough, and the tribunal should have requested for the productions of the audit report, but the tribunal didn't. And relying on these two grounds, the court concluded that there was the procedural breach of Article 46, Part 2 of the Law on Commercial Arbitration. The tribunal also breached the procedural breach of the impartialities obligation, and they annulled the award. So I mean, this is the end of my presentation. But throughout this discussion, like we just want to debate to you, to narrate to you how inconsistent the patterns of the arbitration in Vietnam, how the court take the view of the same issue, the same matters in different cases, and how the parties should avoid, they should know the pattern and to avoid the risk for their arbitral award to be annulled in practice. So thank you very much.
Thank you so much, both to Linh and Thuong, for such an insightful and informative presentation, which first highlighted the good work of the VIAC and also so many key takeaways to be gleaned from the recent decisions of the Vietnamese courts. I'm sure our audience will have a lot of questions to pose to you during Q&A. So if I could invite our audience to post questions in the chat box, and I'll field them accordingly. And also we'll be sure to circulate the slides after the webinar on account of the minor technical difficulties which we encountered earlier. So without further ado, I'll hand over to Linh for her presentation. Linh, over to you.
Thank you, Dawn. Good afternoon, everyone. Thank you for being here with us today. I'm Linh from Stephen Thiry and Sudha Partnership, and I'll be speaking on evidence in arbitration from the Malaysian perspective. Let me just share my slides first. Can you see my slides?
Yes, we've seen it.
Thank you. Okay. So arbitrations in Malaysia are governed by the Arbitration Act 2005, and the rules that are commonly adopted are the Asian International Arbitration Center Arbitration Rules, also known as the AIAC Arbitration Rules, which incorporates the ancestral arbitration rules. It is also quite common nowadays for parties to adopt the IBA rules on the taking of evidence in international arbitration. And as with the other aspects of arbitration where party autonomy is respected, parties can agree on the evidential powers of the tribunal in the arbitration agreement by reference to the arbitration rules, by agreement at a later stage, or by adopting a particular jurisdiction's procedural law as to evidence. As a start, the rules of evidence in civil litigation in Malaysia are regulated by the Evidence Act 1950. Section 2 of the Evidence Act, which has been produced in the slides, provides that the Act does not apply to arbitration proceedings. This, however, does not mean that an arbitrator can conduct the proceedings according to his own whims and fancy. As held by the Court of Appeal in Pembinaan LCL and Hartela and Hartekon, the exclusion of the Evidence Act only means that an arbitrator is not bound by the strict rules of evidence which are applied in court, and it is not a valid objection to the proceedings if the arbitrator has departed from some technical rules of the Evidence Act. However, it is important to note that the general principles relating to the law of evidence, such as the non-violation of the rules of natural justice, do apply to arbitration proceedings. And this is in line with Section 37, subsection 2B of the Arbitration Act, and also the High Court decisions in Juro Development and Conef Corporation. Moving on to burden of proof. Sorry. It is right that the burden of proof lies on the party who asserts. And in an arbitration, the burden of proving a claim rests on the claimant, and in the case of a counterclaim, on the respondent. The standard of proof is on the balance of probabilities. It is important to note that even if the arbitration proceedings are on an ex parte basis, the burden of proving a claim shall rest on the claimant. Moving on to the Arbitration Act and the rules. The relevant provisions have been reproduced in the slides, and I'll start with Article 27 of the Arbitral Arbitration Rules. Article 27 of the Arbitral Arbitration Rules are very broad and, in fact, skeletal in nature. And a number of key takeaways from this article are as follows. First, parties must prove their case. Second, witnesses may use witness statements. Third, the tribunal has the power to require parties to produce documents, exhibits, or other evidence within a certain period of time. Fourth, the tribunal shall determine the admissibility, relevance, materiality, and weight of the evidence offered. And lastly, the tribunal has the flexibility to adopt certain stricter rules of evidence which are familiar to the parties, or to take a more liberal approach. Next is Section 21 of the Arbitration Act. The key takeaways from this section are, first, subsection 1 allow the parties to agree on the rules of procedure. The parties may, for example, agree to do away with oral evidence and base the proceedings purely on documentary evidence. Subsection 2 provides the tribunal with the power to conduct the proceedings in such manner as it considers appropriate. And when the tribunal invokes its powers under subsection 2, subsection 3 provides that the tribunal has wide powers to decide the matters set out thereunder, and it includes admissibility, relevance, materiality, and weight of any evidence, to draw on its own knowledge and expertise, and to order discovery and production of documents. As provided for in Section 21, subsection 3A of the Arbitration Act, an arbitral tribunal is conferred with the power to determine the admissibility, relevance, materiality, and weight of any evidence. The tribunal normally decides on these issues at the hearing. And as the tribunal is not bound by the general rules of evidence, most tribunals in practice adopt a flexible approach to the admissibility of evidence that may genuinely assist them in determining the dispute. Nevertheless, tribunals will consider the weight to be assigned to evidence of questionable nature, such as hearsay evidence. And although Section 21, subsection 3B of the Arbitration Act provides the tribunal has the power to draw on its own knowledge and expertise, the Court of Appeal in this case, Seguros, held that this power has to be read together with the arbitrator's overarching duty to act fairly and in accordance with the rules of natural justice. So in this case, in reaching his decision, the arbitrator had relied on two pieces of extraneous evidence. The Court of Appeal found that the two pieces of extraneous evidence were based on the arbitral's own knowledge and expertise. However, the courts found that the arbitrator had committed breaches of natural justice by failing to afford the parties an opportunity to present their case on the extraneous evidence. And this is what the Court of Appeal said. The arbitrator's duty to act fairly and to always afford parties reasonable opportunity to present their case or arguments on any live issue in the arbitration had to endure throughout the whole arbitral process to protect the sanctity and finality of the award and for sound business and commercial practice. In the present case, absent any express agreement to the contrary, the arbitrator was obliged to have invited the parties to deal with or respond to the two pieces of extraneous evidence and his line of reasoning on the issue of causation. And just as a side note, the Court of Appeal in this case also found that the High Court had made an error in refusing to set aside the arbitral award on the ground that the respondent was not prejudiced by the breaches of natural justice. A mere finding that the rules of natural justice have been breached is in itself insufficient to set aside an arbitration award. It has to be shown that the breach was significant or serious, such as to have had an impact on the outcome of the arbitration. Prejudice is a relevant consideration, but it is not a requirement. And the Court of Appeal decision in this case was subsequently affirmed by the Federal Court. I'll now move on to discuss the various types of evidence. So in practice, the main methods of presenting evidence to the arbitral tribunal are, number one, tendering relevant documents. Number two, tendering direct or written evidence of the witnesses of fact and or opinion. Number three, giving the tribunal an opportunity to inspect the subject matter of the dispute, for example, by carrying out a site inspection. The tribunal has no right to dictate the way a party presents its case, nor hamper it unduly from doing so. As discussed earlier, the tribunal has the power under Section 21, subsection 3F of the Arbitration Act to order discovery and production of documents or materials within the possession or power of a party. This is usually done at an early stage of the proceedings by way of a written schedule. The IBA rules of evidence can be very helpful when it comes to discovery because it provides a set of circumstances under which a refusal to produce documents may be reasonable, such as lack of relevance to the case or lack of materiality to the outcome of the case, or that the document is protected by legal privilege, or that the discovery imposes an unreasonable burden on the responding party. And as a general rule, there should be no discovery against a non-party to the arbitration proceedings. In this case, Christopher Martin Boyd, the defendant, applied to the arbitrator for an order of discovery against the plaintiff to produce documents belonging to a third party. The arbitrator dismissed the defendant's application. The defendant then took it up to the High Court. The High Court similarly dismissed the defendant's application. In upholding the arbitrator's decision, the High Court held that the arbitrator had no jurisdiction to give any order to any third party who are not involved in the dispute before the arbitrator. However, where it involves a third party, a party can, with the approval of the arbitral tribunal, apply to the court for assistance in taking evidence. And this is provided for in Section 29 of the Arbitration Act. And on this application, the court can order the attendance of witness to give evidence or, where applicable, produce documents on oath or affirmation before an officer of the court or any other person, including the arbitral tribunal. And the governing considerations to justify the issuance of a subpoena to produce a document or summon a witness are relevancy and materiality. And it is right that the onus lies on the applicant to prove the same. And interestingly, in such a situation, it is immaterial that the person subpoenaed is not a party to the arbitration proceedings. And this was held by the High Court in Conneff Corporation. However, if the subpoena was issued for a non-legitimate purpose or is oppressive, then the subpoena would be set aside. I would like to now move on to witness evidence. When it comes to factual witnesses, it is common practice for witness testimony to be given in the form of sworn written witness statements. The tribunal will set down the timelines and procedure for the completion and exchange of witness statements. Witness statements in rebuttal may also be exchanged if directed by the Arbitral Tribunal. And following the exchange of witness statements, factual witnesses will also be called to give oral evidence at the evidential hearing. And on the other hand, expert evidence is usually presented by way of a written report. In Malaysia, it is common for the Arbitral Tribunal to direct the experts to prepare a list of LET, list of expert or technical matters, also known as the LETM, where agreed and non-agreed technical matters are set out. The contents of the written expert reports may pertain only to non-agreed technical matters, depending on whether there's any agreement on technical facts by the experts through the LETM. And although Sections 26 and 28 of the Arbitration Act provide the Arbitral Tribunal with the power to appoint its own expert, in practice, party-appointed experts are more common than tribunal-appointed experts. As a matter of practice, the experts should also submit a description of their qualifications and a statement of impartiality and independence to the tribunal and the parties. Parties should be given both a reasonable period to inquire about the intended appointment and an opportunity to raise any objections on the expert's qualification, impartiality, or independence after the appointment of the proposed expert. Following the exchange of expert reports, the experts may be examined orally at a hearing. In Malaysia, witness conferencing for experts is used, and it is also known as hot tubbing. The format and procedure of hot tubbing differ from case to case. The tribunal may decide for one expert to give evidence after the other. The tribunal could also decide that the experts are to give evidence together and to take their evidence on an issue-by-issue basis. So very recently, in the case of Linsan Engineering, the Malaysian High Court had, for the first time, found that party-appointed experts owe an implied duty to courts to ensure the ability and availability to give evidence at trial. So in this case, the defendant appointed the plaintiff to supply manpower and tools for a power plant project in Malaysia. Having commenced work, the defendant terminated its contract with the plaintiff. And this prompted the plaintiff to commence a claim against the defendant in the Malaysian High Court for the value of completed work. The defendant appointed 2 quantity surveying experts in the court proceedings and submitted a joint expert report by them. However, following the close of the plaintiff's case, the defendant applied to the court to file a fresh expert report by a replacement expert, on the ground that the defendant's original 2 experts were either uncontactable or unable to testify due to conflicting work commitments. The court dismissed the defendant's application on 2 grounds. First, the general prohibition against parties calling fresh experts after trial. And second, the potential prejudice the plaintiff would suffer if the application was granted. And notably in this case, the court also went further to find that the defendant's experts had, by their conduct, breached the implied duties to the court. It is a well-established principle under Malaysian law and other common law jurisdictions that experts owe an overriding duty to assist the court on the matters within their expertise. The court found that it was necessary to imply into these 2 additional duties for experts. And they are, first, a duty to ensure that the instructing solicitor can contact them for the purpose of the trial. And second, a duty to ensure that they can give evidence in court, either physically or virtually. The court viewed that it was necessary to imply these duties to avoid the appointing party from being unfairly prejudiced by its expert's own failure or refusal to attend trial. So this case introduces a new dimension to expert duties in Malaysian law disputes. The expanded duty restricts the manner in which experts arrange their practices and imposes a positive obligation on experts to ensure that they are able and have capacity to testify at the trial. And although this case considered the expanded duties within the context of Malaysian litigations, but just like the ICARI refer principles, this common law refinement could arguably also extend to domestic arbitration proceedings in Malaysia. And in the field of international arbitration, the implications appear to be more limited. And this is because the IBA Rules of Evidence set forth strict consequences in case an expert does not appear at the oral hearing. And according to Article 5, Paragraph 5 of the IBA Rules of Evidence, the Arbitral Tribunal shall disregard any expert report by the party-appointed expert if he fails to appear for testimony at an evidential hearing, unless, in exceptional circumstances, the Arbitral Tribunal decides otherwise. So that's the end of my presentation today. Thank you.
Thank you so much, Linh, for such a focused and enriching presentation presented in such a digestible and easy to follow format, and also for highlighting the leading Malaysian cases and the principles arising therefrom, especially in relation to the tribunal's powers to order discovery against non-parties to an arbitration, and also the rather onerous duties owed by the experts to the court, which I wasn't completely aware of before your presentation. I also expect that we'll have some questions on Redford's schedules and the use of the LETM during the Q&A session. So on that note, the time has come for a short Q&A session. Can I please invite some questions from the floor, particularly from some of my colleagues who I think are ready to ask some questions, please.
Hi, Linh and Thuong. Thanks so much for taking the time to give us the talk today. Just have a quick question. It wasn't too clear. In the absence of any arbitral rules, how does the arbitral tribunals in Vietnam consider and evaluate evidence?
Thank you for the questions. It's indeed very interesting. Actually, how the tribunal would evaluate the evidence, this really depends on tribunal to tribunal, because in Vietnam is not limited on the sources. I mean the numbers, the nationalities of the arbitrator. So they may come from different legal traditions. So start with the proceedings. So just recently, the tribunal, as guided by VILAF, for example, that they would hold a case management meeting to decide in advance the procedure proceeding, like how the proceeding would be conducted. So in which the tribunal and the party may agree in advance how they would run the proceeding, the rules to be applied prior. So if the tribunal they come from different legal tradition, they may bring the tradition to the country and they decide on that basis. But like in domestic arbitration purely, so here in Vietnam, because we do not have the traditions of determining the evidence on the criteria like relevance, materialities, and admissibilities of the evidence. It's really depend on case by case basis on the view of the tribunal, how they evaluate the evidence that's submitted to them. But in such a cases, we really, the situation is really difficult, because here in Vietnam, there's no, because come back again, there's no specific rules of document to be produced, and at what stage and within what time limit the party have to produce the document to prove the case. It's a general, like the production to be, it looks like the general discovery. So the party will submit whatsoever they think that it will submit they have to prove the case. If we have them to prove the case, and the tribunal in a lot of the case they will be overburdened, like overwhelmed with the document. So they may view this document and they miss the other one. So it's the risk. So without the very clear guidance, it will be really tough for the tribunal to decide the case because of the volume of the document submitted to them, and basically everything will be considered as evidence.
Yeah.
And yes. And I also referred to the decision 11 that I discussed earlier. So in that case, the tribunal the court take the view that because the tribunal rely on a single expert report that produced by the claimant as a procedural breach. So by this decision, is it also very, you can see that it's very unclear how the court will be certified that to show that the tribunal indeed review all the evidence or rely on all evidence that placed in before them. So yes, so my colleague Linh add something else.
Yeah, I just want to add that that according to the law on commercial arbitration of Vietnam and VIAC rules, the party has the right to submit the document and evidence before the final hearing. So it's quite overburdened for the tribunal. If at that time the tribunal received the evidence to review, and the period of time for the tribunal to issue the award very short, only 30 days from the final hearings. And if on the final hearing, the party submit high volume of evidence and documents for the tribunal to review, then it's quite troublesome for the tribunal. Early last year, the IAC decided that they issue a kind of guidelines for all the tribunal that we should hold a kind of a CMC, and we also should issue a kind of PO for the parties so that the party can agree on the timeline, agree on about the evidence document production, and so on, and set a cutoff date for the party to submit the documents and evidence, so that probably be less burden for the tribunal. Yeah.
Thanks so much, Linh and Thuong. That was very clear. Thank you.
Thank you, Jerry, for the question. Anyone else? Okay, we've got a couple of questions in the chat, so I'll just read them out. This one is from Sabrina, and it's to Yilin. So Yilin, Sabrina is asking, you mentioned that the format and procedure for hot tubbing or witness conferencing may differ on a case-by-case basis. In some instances, experts give evidence concurrently. In your view, what are the advantages and disadvantages of experts giving concurrent evidence?
I'll start with the advantages. I suppose when the expert gives evidence concurrently, it helps to refine and identify the real issues in question. It also allows the experts to engage directly with each other and to respond to the other experts instantaneously. I think this may be very helpful to the tribunal, especially if the issues are very complicated or difficult. And as for the disadvantages, the greatest disadvantage that I can think of is when the experts have very different personalities. An expert with a stronger personality can be overbearing the other expert. And this is especially because the experts tend to advocate for their own point of view or to advocate for the party appointing them during hot tubbing. And the expert with a weaker personality may end up losing out. Yep.
Thank you so much, Yilin. I think that more than answer Sabrina's question. Linh, Priscilla from STSB had a question, and it's in the chat box. I'll just read it out to you. She asks, what documents must a party disclose to the other side and or to the tribunal, and whether anything is compulsory? Linh, I think you're on mute.
Can you hear me now?
Yes, I can. Yes.
Okay. Sorry. Like I said, that the burden of proof depend on the belong to the party who make claims. So in this case, the claimant will have the obligation to provide the evidence, and in the counterclaim, the respondent also have to provide the evidence. There's no specific requirement that which kind of document you have to provide, but this depends on the party, and the tribunal will look into the document to see whether the tribunal need further the party to provide further evidence for their determination and consideration. And like I said, that recently VIAC adopt a kind of CMC and the PO in which they will set out the timeline for the party to make a kind of document production for either party to review, and also for the tribunal to look into and may require further document from either party. And the party may refuse to provide the documents, and at that time the tribunal will decide on what the party submitted to them for determination. And what?
Thank you, Linh. Yes. Priscilla, I think that answers your question in the chat box. Yilin, I've got one for you. We all know that experts are expensive, and we've seen that in practice. Could you give us some tips, perhaps, on how to control costs when it comes to using expert witnesses?
Okay. I think the first question to ask is whether expert evidence is really necessary. The role of an expert is really to provide an opinion based on their experience, knowledge, and expertise. But in some situations, a factual witness who has sufficient experience and expertise in a particular field can also play the same role. For example, a QS versus a quantum expert, or an architect versus a delay expert. So I think that's the first consideration. And secondly, parties can also consider appointing a single joint expert as opposed to appointing two experts for each side. And this will definitely save costs because the expert's fees will then be divided by two. And I think it is also important to ensure that the issues to be addressed by the experts are clearly defined. This helps to focus the expert's evidence and to prevent the expert from rendering an opinion on unrelated issues.
Thank you, Yilin. Very practical tips there from you. Thank you. There's a question from Aaron Matthews. His connection is not so good, so I'll ask it on his behalf. It's to Linh and Thuong. Linh and Thuong, Aaron asks, in Vietnam, is witness conferencing council-led or tribunal-led?
It's the very common practice is council-led. Yeah. because you know that for the expert in Vietnam, many of them not familiar with arbitration or litigation, and we prefer that the council may lead the cross examination, so that can make a pressure on the expert or the witness. So normally we, of course, it depends on the case by case, but normally we adopt the kind of counsel.
Okay, thank you, Linh. I'll open the floor up again. Any further questions?
Hi, Linh and Thuong. Just Jeremiah here again. Just have another question to follow up on my previous question. So from what I understand, there's a very wide discretion to evaluate evidence in Vietnam in arbitral tribunals. So my question is a misapprehension of evidence or a mistake as to the substance of the evidence a grounds for reviewing an arbitral award by the courts?
Okay, thank you for your questions. Indeed, you know, like reviewing the evidence and deciding the substantive issues, indeed is something, the substantive matter does not allow the court to review or to revisit. But the court had many ways to, you know, to circumvent the situation if they want to review the substance of the case. So in many cases, the court would review, like, you know, like relying on, if you go through the decision that published by the court on the decision to annul an arbitral award and to not annul an arbitral award, it is very common that the party would plead the case on over again. And they would complain like the tribunal missed this document, missed that document. So in many cases, the court said that no, it's the substantive issue, we're not going to review it. But in a lot of cases, the court dig in and they review the evidence that the argument that pleaded by the party, and to decide like whether they would say they would elaborate their view, the court would elaborate their view and to agree and to disagree with the tribunal, and they conclude that by not relying on an evidence or by wrongly relying on an evidence, the court breached the impartiality's obligation. So for your information, in Vietnam, we don't have a very high threshold for due process or how to determine if the tribunal impartial or not. So the court would have very broad discretion in deciding where the natural justice was secured during the proceeding, or whether the court was biased or the impartial or not. So yes.
I just want to add that because you know that when an award challenged by a party, in principle, the court is not allowed to review the substantive issues of the case that heard and determined by the tribunal. But because the gray area between the merit and procedure, and the party normally will draw a kind of tactic that they link some issue about the procedure to the substantive issue. So when the court reviews the procedure issue, they also look into the merit things, and like Thương mentioned in her presentation, in some cases the court also look deep into the substantive issue, you know, to decide whether to cancel or annul the arbitral award or not. So that's something for the practitioner in Vietnam, many them take advantage of this.
Thanks very much, Linh and Thuong. That was helpful. Thank you.
Thank you, Linh and Thuong. Very, very comprehensive answer. I have one for Linh from Cheng Leong. Yilin Cheng Leong is asking about Redfern schedules. You spoke about Redfern schedules during your presentation. Could you please briefly explain what a Redfern schedule is?
A Redfern, sorry, a Redfern schedule is a table which provides the framework within which document production or non-production takes place. So the process starts with the requesting party filling out the first 2 columns, describing the document or category of documents which the requesting party wishes to see, and also explaining the relevancy and materiality of the document. A third column is sometimes used for setting out why the requesting party believes the document is in the possession of the responding party. The table is then sent to the responding party, who will indicate in the response column whether they agree to the request or if they have any objections to it. And the requesting party will have a chance to reply to any objections by the responding party before the table is then sent to the tribunal for decision. So the tribunal will then make an order in relation to any request which have not been agreed or which the withdrawal of the request has not been reached. Yeah. Thank you.
Thank you, Yilin. I think that answers Cheng Leong's question. Can I invite any other questions from the floor? We just have a couple more minutes before we wrap up. Okay, I have one for Linh and Thuong. I want to ask whether the coaching of witnesses is permitted in Vietnam. For example, it's common practice in the US for lawyers to be very much involved in the preparation and the coaching of witnesses prior to the giving of evidence. And that includes questioning them directly on evidence that they have given in their witness statements. Now, that's not permitted in England and Wales, so I was just wondering what the Vietnamese position was.
So may I rephrase the your question that you're asking about, like if witness is allowed to give their witness statement but not specify?
So the extent to which counsel is permitted to coach a witness, so posing questions and answers and rehearsing with the witness, if you will.
Okay. So here in Vietnam, because we don't have the kind of like traditions of like a very clear specific set of evidence. Like we don't have evidence act, and we don't have any set of clear rules regarding the party and the counsel through some of these things. Then it's really depend on the counsel and the party how they want to run the cross-examination and everything. So, and because we don't have the tradition, then in practice, it's really depend on the party and the counsel whether they want to train the witness before the hearing or not. It's not only about the substance, how they should answer the questions or curve, but it's also to train them with the atmosphere and the the atmospheres of the hearing, because not to train them mentally also, because in a hearing they may face with very harsh and pushing questions from the counsel, the opposing counsel, and also from the tribunal. And at least they should to train them to be familiar with the hearing room, to know to whom they should direct the answer, because here like it's heard, and also like people, we are not familiar with the type of hearing like that, and because there's no specific rule guiding the parties, then indeed it's not type like if they get to know they would punish or it could be considered as a procedural violation or a what.
Yeah, I think that because there's no restriction of prohibition. As a matter of practice, I aware that many of them many counsel would train their witness or expert before the hearing or to attend the hearing, how they should respond, to which extent they should respond, and they also have some kind of rehearsal for the witness and the expert before the hearing.
Thank you, Linh and Thuong. That was very helpful. It's somewhat different to the position here in Malaysia, so it's good to hear what the practice is in Vietnam. Thank you.
But
okay,
I think that I also attend some Singapore International Arbitration. I also see that to a certain extent, the lawyer there also can have some kind of training to the expert and witness. So I'm not quite sure whether Malaysia and Singapore are different, but I see that to a certain extent they still can organize kind of training for the expert and the witness.
Yes, I think it really depends on the ethical rules in force. Obviously, it differs from jurisdiction to jurisdiction, but here we're generally quite cautious about witness coaching.
I just want to add,
yes, please.
Yes. Even though here we because we don't have the specific rule that restrict the counsel to the person to train the witness, but I think that in the hearing room, we still don't interact with the witness. I mean, like to keep the witness very impartial. Like the views is neutral and they give what they truly believe is in the case. And we don't, the counsel didn't interact with the witness. We don't look at the witness or to give some kind of like leading interaction or guidance to them because it would discredit them. So yeah. So even though we may give them some training, but we didn't interact with them throughout the year.
Yes, the practice is much the same here, Thuong. Thank you. And I think you've hit the nail on the head. It goes to witness credibility. So that has to be preserved at all times. Just one final question, because I'm conscious of the time, and this is for Yilin from Arjun. Yilin, Arjun asks about and is asking about the LETM. He asks what it is and if you could explain, shed some light on to what an LETM is, please. Thank you.
LETM stands for List of Expert or Technical Matters. It is a joint document prepared by experts from both sides. And the purpose of an LETM is really to identify the extent of any agreements or disagreements between the two experts. And upon identifying the areas of disagreements, the LETM can serve as a useful parameter for the expert reports. Yeah. That's all done.
Okay, thank you so much, Yilin. Okay, well, that concludes the webinar for the day, everyone. I'd like to thank our esteemed speakers, Linh, Thuong, and Yilin for so generously sharing their views with us today, and also to Yilin for powering through, although she's unwell with a sore throat. Thank you so much. And thank you also to our obliging and interactive audience for their very keen participation. It's very much appreciated. I've enjoyed moderating this webinar. I'll be sure to email along the presentation slides to all of our attendees. Thank you once again and have a good weekend, everyone.
Thank you, everyone. Thank you, Dawn.
Thank you.
Thank you, Linh and Thuong.
Yeah, thank you.